Hey guys, and welcome to today's video. Today we have a few hearings to cover on a sovereign citizen in court charged with child neglect and facing 10 to 32 years in prison if convicted. And after giving it some deep thought, he came to the conclusion that the best thing for him to do was fire his attorney so that he can represent himself. What a dumbass. So, let's begin.
All right, I can call Mr. Stickrod, Richard Stickrod, 26CR167. He appears out of custody here for an appearance at counsel. Mr. Stickrod, I didn't see a public defender application or an entry of appearance from a private attorney. So where are you at?
I guess I'm gonna represent myself for now because I got a couple things I need to get like established or settled because I don't know really what's going on. It's my first time like really getting charged with anything besides a speeding ticket.
So did you apply for the public defender's office?
I was going to,
Okay,
but I have a court-appointed lawyer for my family law,
sure.
and I've been waiting 2 months for my discovery, and I've been getting railroaded everywhere I go with everything. I filed an FOI
So,
or whatever.
I'm going to stop you. The public defender's office in your criminal case, you're not going to have an issue getting discovery. You need an attorney. This is a very high charge, and if you've never been through this before, then you need more than ever. You do not want to represent yourself, and I can give you a million different reasons why.
I'm sorry, I don't mean to interrupt. I just wanted them to state their claim. That's all I wanted to do was here because I didn't even know like what's going on.
So the district attorney's office has filed a charge, and I gave you a copy of that complaint information, right? It gives you the law. It says under this statute, here's why
And I got their
We-
affidavit,
right. So,
and it's
and it's short because they don't have to be long.
matches.
So
Dates, times, nothing matches.
what's going to happen, why you need an attorney, is that attorney is going to basically enter their appearance and they're going to request all the discovery from the district attorney's office. I've read the probable cause affidavit. I'm familiar with this case. So I know there's going to be a lot of discovery. There's going to be a ton of stuff, medical stuff. There's going to be a ton of stuff from DHS. There's going to be a ton of stuff from the police investigation. So the discovery is going to be voluminous.
Well-
And here's the thing about it. There's going to be video, photos. There's going to be all these different things that on your computer at home, you probably don't have programs to even open half these files. If you apply and you qualify for the public defender's office, I appoint an attorney from their office. They have over 80 attorneys that work at that office that all they do is practice in this courthouse and handle these cases and work with this district attorney's office. And they're going to meet with you on many occasions at their office to go over all this discovery and explain to you, whether there is sufficient evidence for this charge or not, but you need an attorney. I'm not going to let you to just move on and self-represent yourself. At the very least, you're going to apply for the public defender's office.
Okay, but I was wondering, can I just say, like, I want to avoid judgment of the family court and to get my protection order reduced because even they are stating that they didn't want me to have the protection order. Like,
I have no idea what's happening with the family court case.
I haven't seen my son.
I know.
I haven't seen my daughter at all. I have no conflict.
I know. And so I know what you're talking about, what's going on. I have no idea what's going on with your family court case. And generally what happens is these two cases kind of will work together. What will happen is a lot of the orders in this case regarding your time with your children or parenting time will be mirrored. But
They don't even talk to me. The caseworkers don't talk to me.
that's with the family court.
January
Mr.
9th was the last time my caseworker talked to me.
Mr. Stickrod, you need an attorney. The family court, they have control over parenting time and any time what you get with them, and the criminal court is going to follow
They
those
avoid
orders.
judgment on that?
This is
I
my
don't have-
family court. This case is not in front of me. I'm not
I
doing
have
anything.
not one
with the
signed order
case.
from a judge from that court.
I-
Not
th-
one proper
It's not,
signature.
it's not this court, so I can't help you with that. What I can tell you is that
I can
any
void judgment?
orders no, I can't void judgment.
Not you.
on
I'm
any-
saying I can void judgment. As a living, breathing man, I can void judgment, correct?
Okay. If that were true, then every living man could just void any judgment ruled on him by any judge. Unfortunately for you, that's not how this works, and you're an idiot.
I,
Human rights, that's a human rights violation.
for your family court case? No,
Correct,
I
but
don't
do I due
believe you can
process?
just say judgment is voided. No, I don't believe that's something that you can do, but you need an attorney to help
Is that
you
a
with
yes or
that.
no, please? I'm sorry.
It's not that's not my case or my courtroom. So I'm not going to give you any legal advice or answer any questions for you about that case. You need an attorney. So I'm going to order you to apply for the public defender's office, which Mr. Stickrod is what I did at the last court date. But I'm going to give you another chance to get that done.
Can they
You
state
need
their
help,
claim right now?
Miss Thomas.
It says on the paperwork that I could, you can state your claim right now and I can face this right now.
No, you can't.
We
You
can't.
got to fill this out because both
Oh, you're
I'm
good.
the
You're
prosecutor,
good.
but I agree completely with the magistrate that you need to have an attorney.
I just
So-
want to face my accuser. That is all. And it has to be a living, breathing person.
Yes, but we're not at that point yet. Before we can do anything.
It said on the paperwork that I had last time that I could settle this right now.
Mr. Stickrod, you need to listen to me. I have a whole courtroom of people here that their cases have to be heard. I ordered you last time to apply for the public defender's office.
I would like the motion for dismissal.
I'm denying that oral motion for dismissal.
Under what grounds?
I don't have any power to dismiss your
Explain.
case. Mr. Stickrod, I'm going to remand you here in a second if you don't start listening to me because
Is that legal?
you're taking everybody else's time away right now. You need to apply for the public defender's office. I'm ordering you to do it again. I'm going to give you 2 weeks to get it done. If you don't get it done at the next court date, I'm going to revoke your bond and remand you because I'm ordering you to do something and you're directly not doing something that the court is ordering you to
Lawful
do.
order, right?
Yes. But if you have a lawyer help you with that, then they could file something if they feel that it's not lawful. But you need someone to help you.
She's trying to help you. She's trying to help you.
So Mr. Stickrod, I'm going to have
All
you
of my
back here.
process has been violated throughout this
She's
whole.
trying to give you due process by having you have an attorney.
Yeah, but when y'all locked me up and said I didn't have access to a law library, when I didn't give up any of my rights last time, I had a lawyer for family
Mr.
court.
Stickrod, you're not in custody right now. So you can go to the law
No, my
library
kids have been kidnapped, is what I'm saying.
because you're
That is
facing
what
a
I'm-
very, you're facing
not
a
seeing
very
my
serious
kids.
charge. Mr.
All right, yes,
Stickrod, your
ma'am.
next
I'll-
court date is going to be an appearance of counsel on March 5th. That's a Thursday. I'm giving you 2 weeks. And it'll be at the same time, 3:45 in this courtroom with me, Division DST. I'm ordering you to apply for the public defender's office before that next court date. If not, then I'm going to consider revoking your bond at that time.
But for family court, I can't void judgment.
This
for
is
the
not
second-
family court. I'm not answering any more questions. Your hearing is done. See you on the
Yeah,
5th,
thanks very
sir.
much.
Okay, so that's the end of his first appearance. Now we head to his next appearance where he gets appointed a public defender. For a moment it appeared as though he came to his senses and stopped larring as Perry Mason. But all of that will change.
This is Richard Stickrod, 26 CR 167. Sir, good to see you again. I know this has been a lot and you're here for an appearance of counsel. I had asked Mr. Tiplitz to talk to you a little bit before maybe getting advice from an attorney or someone that could just talk to you from the public defender's office might be helpful, but go ahead.
It's been a little bit of trouble actually finding a lawyer that wants to take my case. But so I just don't understand quite what's going on, like with the whole court situation, and how it's been happening and been dealt and all that. I've never consented to anything. Like I didn't waive any rights or anything like that. Like it said something about a waived extradition. Never did that. Never
Oh.
consented to anything that wasn't like under duress or where I had to do it.
So let me go back to a couple things. One, when you posted bond and you did that through a bondsman, through Dennis Blackwell, it's your bondsman that has you sign a waiver of extradition, saying that, hey, if you go on the run and you go to another state and you get picked up in Utah, that you're waiving your right to be extradited back to Colorado. So that comes with posting a bond and being out of custody. So you may not have realized what you were signing, but I have a waiver of extradition that you signed.
And what dictionary are we using?
Well,
Like Black's Law or Oxford or
kind of a combination of both. It depends what words you're talking about. Extradition is certainly in Black's Law dictionary. I have a copy if you want to look through it, but I can print you out this waiver of extradition that you signed that says the following: if I'm arrested in another state, I consent to extradition to the state of Colorado. And among other things. So that's answering one of your questions
I'm
about
just saying, if that's a
extradition.
contract that I signed, then that's null and void because I was under duress.
That's something that you need to talk
And
to your bondsman about.
also, am I a person or a man to you, like what you see me as right now?
You're a human being.
All right.
You're a
Just
human
making sure I'm not a
being.
persona, not some corporate entity, all caps fictional name.
You're a human being. You're Richard Stickrod. This is,
Uh,
you're here on a case. So I want to try to answer your other question, what happened, right? So the Department of Human Services was involved with your kids, and they went through the legal process on their end, right?
But they committed perjury. That was
But you
what
got to let me finish, Mr. Stickrod. I don't know about perjury. I don't know about what DHS did and everything like that. But I know there was an investigation, that then the law enforcement got involved. They did an investigation. They interviewed people. They filled out their reports. They provided their investigation to the district attorney's office. That's who Mr. Parsons is with. And the district attorney's office reviewed the case, and they determined that they had enough evidence, probable cause, to file a charge in your case. And that's what they did. They filed a class 3 felony level charge in your case.
Well,
And that's how we've gotten to this point.
you said they had 10 days to file.
They did not. So the charge has been filed.
Well,
That's a moot point.
They were filed, not filed, but my arrest warrant was for the 15th. I was arrested on the 23rd, and then I was released on the 30th, and that's the day that they filed their charges.
They filed charges on, I see a complaint information that was filed February 2nd. There is no law that says there's no rule in El Paso County, and there's no law that says the district attorney's office has 10 days to file charges from the point that you're arrested. It's a practice we like to follow here in El Paso County, because we want, if the district attorney's office is going to prosecute somebody, we want them to get, determine that within a timely manner. And so the process we like to follow is they're going to do that within 10 working days. And so I would say that happens most of the time, and sometimes it doesn't. But in your case, charges have been filed.
So
These are all great, very good questions. These are all very good questions. But this is why an attorney is going to be so helpful and valuable to you. I understand that hiring a private attorney is super expensive. Finding an attorney to take a case like this, also difficult, because it's going to involve a lot of work and time, which makes it even more expensive. You likely qualify for the public defender's office. I've now asked and ordered you to apply for their office. I just want you.
I haven't filled out.
You got to turn it in, though. I can't approve that application because I don't work for the public defender's office.
Oh, my bad. At my last court case, they approved it right there, and he came right.
That's a different court
Yeah,
case.
yeah.
Yeah, and they can do that in those proceedings. And I might be able to have Mr. Tiplitz approve it today.
And also, I have a quick question. I didn't receive any of the surety bond numbers or anything like that for everybody involved, even when I asked for it. So I got all their cards, but I don't have their bond information, which is
I'm not sure, your bond information,
theirs.
whose?
Every cop that was involved,
I,
and
so-
every magistrate and judge and clerk.
So as far as every officer that was involved in your case, anyone that investigated it or wrote a report or anything, that's all going to be provided usually through your attorney, which is they know how to get all of that from the district attorney's office. So you could,
I already did the core and the FOII and all that. Like, I have a certified copy of the case file,
okay.
and
So
all
you
that
can
good
also request that, your attorney's going to request that, and they're going to go through it to make sure that everything that the state has was provided to you. So that's another huge benefit about having an attorney.
there's a bunch of gaps in it. Like the day that my daughter was assaulted, and they punched her in her chest as they were trying to come in the front door.
So that's stuff you got to talk to your attorney about. I won't be able to help you personally get that information, an attorney will. And that's why I keep pushing this on you, is because I know you have lots of good questions. I know you want answers to your questions, and an attorney is going to be able to help you with this. And so I think my goal is to help you by, if you qualify for the public defender's office, to appoint an attorney to your case. And that's going to be the first step to helping you. And then you've got to go through the process, and they're going to help you through that.
Well,
And
I don't understand why an attorney can get it, but I can't. I'm the defendant.
you can both get it. All I'm saying to you is that generally it's easier for the attorney because they do it all the time. It can be hard for the public to get discovery and know what they're missing or not, and all of that. That's why attorneys do it every day for all of their cases, and they're very good at it. And they have support systems and teams that make sure they get everything that they're entitled to have.
I was also wondering why they said they wouldn't give me everybody's oaths, like everybody's oaths of office.
I don't know the answer to that.
There's just a lot of.
I don't
lopsided
know that.
shit. And like, I accept my right to counsel and all that. I just want to make sure everybody knows that all my rights are reserved and all that. Like, I'm not signing away anything.
I haven't had
waiving
you waive anything in here. Anything that you waived before, like your waiver of extradition, that was not something we did in here together.
Oh, yeah,
That
I
was
know
the
that.
process through your bond.
I want to avoid and vacate that one, but
I cannot void and vacate that waiver of
oh
extradition.
no, that's just a personal thing. Like, nobody can
I understand.
use it against me later on. Your clerk's writing it down, right? Just on the record.
I still haven't come to a logical conclusion as to why sovereign citizens think that because everything is on the record, it's somehow a get-out-of-jail-free card. The only thing they need to realize is that it is all on the record. So if they do or say something incriminating, it can and will be held against them at trial.
Everything's recorded, so they don't transcribe everything, because we just record everything. But no, they're not writing this all down to put on the record, because that would take hours. So any more questions for me before I'm going to have you take a seat and recall your case here in a minute when Mr. Tiplitz is free? And if you want to sit down and think some more, you can.
I think he'll still need to go to the office and just have him sign off on that.
Okay. And
They're done today, though, accepting applications. My concern, Mr. Stickrod, is I ordered you to get that application completed and done today, and it's not.
see, I thought
So
it
now-
would be like the last court that I did, where I handed it to you and it gets done.
No. And so now I have to have you back here again just to get that application turned in to see if you're approved.
Okay.
I'm not going to keep doing this. If you have questions about where to go and where to take that and turn it in before next week, I'll answer questions until the cows come home. You've got to follow my orders. You've got to get that application turned in. You need an attorney. I want you to get the help that you need to get through this process. So it sounds like you have some income.
No, I got fired because I was in jail for a week.
Mr. Chiplitz, since he's unemployed, do you know regarding the income that you saw on there?
I got my military disability.
So do you have your award letter for that to show the public defender's office what you receive every month? And I'll just tell you that bank statements aren't enough. They want to see that
I've
award
got my
letter.
bank statement. I think my DD 214 is in my car.
Is that the kind of the equivalent of an award letter to what you get every month?
It's what they give you when you leave the military.
Okay. Does it show what income you receive every month?
Not necessarily, but it shows that I served. And then because my disability, like, it fluctuates.
Okay.
So like right now I'm at 80%, but when I first got out, I was at 50%.
Okay.
And so it just fluctuates from time to time.
Is it change like every year? Do you have to go in and have an assessment to determine the percentage?
Yeah.
Okay. And currently you're at 80%. And does it?
It's like 2,200 a month.
Okay. And that's what you've listed on there for income?
Yes.
Okay. Mr. Tiplitz, I think just given the circumstances and the charge in this case, do you mind if I take a look at the application?
And can I have is it a protection order? Because my son's
I am,
perfect.
I'm going to address that today, but I'm not going to do it right at this moment, but I am going to talk to you about that.
Because my son's perfectly fine. There's nothing wrong with him. Like, and I haven't been able to hold him for like 2 months now. I still don't fully understand the nature of the charges.
I understand that. And that's,
And why are they implicating me? Because I'm the one that took him to the hospital.
They're implicating you because the child was under your care, even if it was you who took him to the hospital. Now, the next hearing is this probable cause hearing. It was long and had testimony from one of the firemen and a detective who responded to the call that your infant son was on the brink of death. Now, I'm not going to play all of the testimony as he just sat there and let his lawyer do all the talking. But to summarize the situation, there was a call about an infant who was sick. The fireman showed up first and noticed a 4-week-old baby who appeared malnourished, weighing only 4 lbs at 4 weeks of age. The father stated that he considered taking the infant to the hospital for about the past 3 weeks. The fireman had a glucometer and the glucose level reading returned a result of 33 milligrams per deciliter, where a normal infant would normally be somewhere between 60 and 100. There was borax covering the floor and almost no formula at all in the entire house. Also, when the detective showed up to serve a search warrant on the house, both of the parents argued with them about the constitutionality of the warrant. If that was me and I was innocent, the first thing I would let them do is clear my name by searching my house. Now, before we move on to the next hearing, I'm going to play the judge's ruling on whether she believed that there was sufficient probable cause to bind over the case for trial.
All right, so the preliminary hearing is a screening device that affords the defendant an opportunity to challenge the sufficiency of the prosecution's evidence to establish probable cause before an impartial judge. The purpose is not to serve as a mini trial, but is solely to determine whether there is probable cause to believe that an offense has been committed and probable cause to believe that the defendant is the person who committed the offense. Probable cause must be established to each element of the offense charged, and it is established when the evidence is sufficient to induce a person of ordinary prudence and caution conscientiously to entertain a reasonable belief that the defendant may have committed the crime charged. The court must view the evidence presented in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution. So I think the arguments the defense makes are good arguments, especially when we have another caregiver involved, that being mom. I am going to bind over the charge here at the preliminary hearing stage. And that's because, number one, it's the purpose of this hearing is just to establish probable cause. So it's not like there's no standard, but as counsel is aware, it's a fairly low standard. And also at this stage, the court must view the evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution. So the people will had to establish probable cause that Mr. Stickrod unlawfully, feloniously, knowingly, or recklessly caused an injury to or permitted to be unreasonably placed in a situation that posed a threat of injury to the life or health of a child, namely Reese, and a lack of proper medical care that resulted in serious bodily injury to the child. So the issue here is whether Mr. Stickrod, whether there's probable cause that Mr. Stickrod knowingly or recklessly caused an injury to or permitted the child to be put in a situation that posed a threat of injury to his life or health. There's a serious bodily injury form that was provided as People's Exhibit 3. It reflects that the injuries constitute severe malnutrition, moderate hypothermia, undifferentiated shock, disseminated intravascular coagulation, and the substantial risk being neurologic dysfunction, risk of organ dysfunction. Um, the argument by the defense is that this could have just been a kind of an onset of a major medical crisis that dad responded to properly. That certainly could have been the case. I think looking at the evidence in the light most favorable to the people and drawing all reasonable inferences in favor of the people. We have here testimony that dad indicated that he wanted to take the child to the doctor for 3 weeks. Yes, that could have been for routine medical care. It also could have been because the child was not doing well. DHS had previously been involved conducting welfare checks because of some sort of concern raised as to the health of this child. When the grandparents come in, they notice that the child doesn't look healthy. Maybe not to the point where they're calling 911, but to the point where they are alarmed and trying to persuade mom and dad, you need to take this baby to a doctor. Dad finally agrees, and when they take the baby to the doctor, obviously he's not doing well. The evidence for me that suggests maybe something going on more long-term would be the severe malnutrition. Again, this is just a reasonable inference that you don't become severely malnourished overnight or within a day period or even 2 days, but the serious bodily injury form indicates severe malnutrition. The detective testified that the doctor told him this baby was quote unquote wasting away, and indicating that he wasn't being properly fed. And when the detective executed the search warrant and went into the home, there were some signs of feeding. There were empty bottles, and there was one, sounds like half-filled container of baby formula. So it appears the child was on formula, not breastfeeding. Both parents could have administered the formula to the baby. And it is concerning that dad acknowledges that there was maybe some sort of issue with the formula. He's not taken to the doctor, and then he's diagnosed with severe malnutrition. That, again, to me suggests something that is not just a sudden onset. Some of these other things, maybe low temperature, low blood sugar, low oxygen. I'm certainly not going to speculate as to, what disseminated intravascular coagulation is. That wasn't explained. I don't know what that is. The child also was suffering from kidney damage. I'm not sure if that is something that can just happen rapidly or if that's something that develops over time, but I think it's reasonable for me as a non-medical professional to know that you don't get severely malnutritioned or malnourished, in a day, maybe even for a baby. So I am going to bind the charge over for trial. And are we setting trial today?
Your Honor, I'm gonna ask for one arraignment date. I understand that people may not have any offers furthering this, but I do think that it's a case where we might be employing some experts. A little extra time before we set speedy would be helpful to look into that, because I know this court doesn't want to set up against speedy.
Sure. Any objection to just one arraignment for everyone to get their ducks in a row?
No, Your Honor, and I'll let Ms. Velasquez know kind of why
Okay.
we did that, just so
Sure.
she knows. And if the defense wants to reach out to her at all about negotiations or anything, I'm sure she's happy to do that.
Okay. Why don't we do May 4th at 8:30 a.m.? May 4th at 8:30. I will return the exhibits to the people, I believe for a prelim, the people upload those? Yes, okay. Is there anything else for the people at this time? Okay, anything from the defense?
Yes, Mr. Dickrot would like to address the protection order,
Okay,
specifically would like contact with his son.
And I would like to be able to go to my mom's house and my grandma's house where he lives.
I know there's a DNN, so I don't know what's allowed in that case.
They said I have to have a professional to go over there, but my mom and my grandma both have said I'm fine over there, you know, even just to see my kid for a little bit. He keeps saying I have to have a professional, but I didn't even.
Yeah. So I need to know exactly what contact is permitted in the DNN, like I'm not changing anything. I don't have a problem modifying the protection order consistent with the DNN, but I'm not ordering anything greater than what's allowed in there.
All right. So, that's the end of that hearing. To be honest, his lawyer did a pretty good job placing doubt on the probable cause, and it would have been in his best interest to keep him on his counsel, but as you'll see in the next hearing, he fires his attorney and doesn't understand.
26 CR 167. Richard Stickrod is here out of custody for a hearing on an Arguello advisement. Mr. Stafford is here. For the people, we have Miss Velasquez. Mr. Stickrod, is it correct that you would like to represent yourself in this case?
Yes, ma'am.
Okay, so a couple questions, and we may not need Mr. Stafford to stick around for too long, but are you raising any sort of conflict with Mr. Stafford where you're asking me to remove him and have a new attorney appointed? Is it that situation, or you just like flat out want to represent yourself?
It's nothing personal with him. It's I was reading I think it's American jurisprudence or something like that.
Okay.
I was just reading the attorney-client.
Okay, hold on to, I don't want you to go too far because I don't want you to tell me anything that might be privileged, especially because we have all of these prosecutors here. So I just, you don't have to necessarily explain the whole thing right now. I just want to make sure I'm framing it correctly. Are you wanting to just represent yourself regardless of like any representation issues with Mr. Stafford? Are you saying, I don't want him to be my lawyer, we have a conflict, and I want you to appoint a new and different attorney?
When I signed the application, I wanted him originally as standby counsel. I didn't mean for him to be my attorney. That's why I signed it the way I signed it, you know.
Okay, so I'm not, so are you asserting any conflict with Mr. Stafford?
No.
No. Are you asking me to remove him and have another attorney fully represent you in the case?
No,
No. Are you asking to represent yourself?
correct.
Okay, and is it part of your request that you have like what you're calling standby, like advisory counsel to give you some like basic information about the process and things like that?
Correct, because this is my first time ever in court, so I don't.
Okay. Okay. There's an important difference there, so that's why I just wanted to make sure that I understood what you were requesting.
I was just making sure that all my rights are still like instilled, you know,
Like
or
intact.
intact.
Yeah.
Like when I signed for him, I did the whole, you know, all rights reserved,
Yeah.
UCC 1-308, all that good stuff.
Okay.
Without prejudice and all that. But when I talked to like my caseworkers about my son or my daughter,
Mm-hmm.
they kept saying I have to talk to my lawyer. So I talked to my lawyer.
Okay.
So I had just fired my other lawyer because I had an emergency hearing because they did an operation on my son without my permission. They've taken my daughter out of town twice without my permission.
Okay.
They have just, it's crazy when you have all of your parental rights taken,
Mm-hmm.
but they took them without even having a signature. So I don't even know. And I got the police chief wrote me this letter because they're going to prosecute the officers that were involved.
Okay.
And I just got this yesterday. The harassment's been, or I got this on Saturday, the harassment from the police. They park outside my house for hours at a time, like every day. It's just,
Okay.
I can't work. Nobody wants to hire me until my trial's over. It's been 6 months. I'm about to be homeless. My mortgage.
__ your mortgage and your homelessness. What about your kid? You know, The one you almost let starve to death. Maybe if you were really concerned with all these things, you would have just let the no-cost-to-you public defender do his job and possibly get you out of the mess that you created for yourself. But don't worry, he's going to explain why he's making such a bad decision as the video goes on.
Okay.
It's, even if I win, I lose. So I'm a little frustrated. So,
Okay. So I'm going to go through the advisement on representing yourself. We have to do that in person so that you understand like what that means and that there's a lot of risks associated with that.
I comprehend.
Okay. So bear with me as I pull that up. And then we'll go there. Mr. Stafford, really the only reason I need you here in the initial part is just to make sure there's not any like competency issues or anything. That's usually a question I ask of you. Okay, so Mr. Stickrod, I'm going to have this conversation with you. I'm going to ask you a ton of questions, so just bear with me. This is to make sure I have to assess and make sure that you understand what it means to represent yourself, okay?
I comprehend. I don't understand.
Okay, so that you comprehend what it means to represent yourself. Okay, how old are you?
36.
Okay, and how far have you gone in school?
I was a little bit of college on.
Okay. With that, I would assume you can read and write and understand the English language. Is that fair?
Correct.
Okay. And are you currently under the influence of any medications, prescribed or not prescribed, alcohol or drugs?
No, ma'am.
Are you clear thinking?
Yes, ma'am.
Do you suffer from or have you been diagnosed with any mental disorders?
No, ma'am.
Okay. And what is your typical occupation?
Say arborist in training. I'm not licensed because I don't know like the mating cycles of beetles and stuff like that, but I cut down trees.
Okay, arborist in training. And you've kind of explained this, and I will say too that you have the right to remain silent. Everything we're talking about is being recorded. You have a prosecutor right here. It's not, I don't need to know the specific details about what you've been accused of or the facts of your case. That is, I don't need to know that for this discussion that we're having. An attorney would tell you, don't tell me anything about the facts of your case. And I echo that. I don't need to know it. Don't tell me about it. Okay. If you do, remember everything's being recorded. The DA is right here. Anything you say could be used against you. And again, not necessary for this conversation we're having. You have a court-appointed attorney, and you've kind of said why you wish to represent yourself. But if you could just repeat that, is it because you just want to be the one kind of on the front line getting the information and having that contact with everybody, or?
That too. Between this case and my other case, there's been maybe miscommunication between me and the lawyers.
Okay.
But when I was reading the attorney, oh wait, hold on. Can't say that. Or can I say that? The attorney-client privilege clause?
Okay. You can, yeah, what did you think it's about?
Might be nothing, but it states, that an attorney's has a superior duty to the courts than the client.
Uh-huh.
So I saw kind of a combative with that one.
Okay.
And I don't want to put him in any positions with what I want to what motions I want to file and stuff like that.
Okay.
He's got a career. I'm just a tourist.
Sovereign citizens think they've uncovered a massive legal conspiracy by pointing out that an attorney's primary duty is to the court and not the client. But they're misunderstanding how the legal profession actually works. An attorney has a professional duty to advocate zealously for their client. However, as an officer of the court, that duty is bound by the rule of law and the duty of candor to the tribunal. That means a lawyer is legally required to fight for you, but they are forbidden from lying to the judge, presenting fake evidence, or filing pseudo-legal motions because you want them to. When your attorney refuses to demand maritime jurisdiction or file a 50-page sovereign manifesto, they aren't betraying their client. They're saving themselves from being sanctioned, fired, or disbarred for filing frivolous pleadings. Under Rule 11.
So you want to kind of be the master of your case, what motions you file, that kind of thing, even if he disagrees with those and wouldn't file them as your lawyer.
Yeah, you could put it that way. I just don't want to put him in a compromising position to where like he can't move up or like somebody will hold something against him for whatever I make him do or something like that.
Okay, I understand. Mr. Stickrod, do you understand that you are charged in this case? And I'm just asking if you're aware of the charge, not like tell me anything about it. I don't, again, want to know that. You are charged with child abuse, knowingly or recklessly causing serious bodily injury. And as charged, what the allegation is that between and including December 7 of 2025 and January 6 of 2026, that you unlawfully, feloniously, knowingly or recklessly caused injury to or permitted to be unreasonably placed in a situation that posed a threat of injury to the life or health of a child, namely a child with the initials RS, and a lack of proper medical care that resulted in serious bodily injury to the child. Do you understand that's what the people are charging you with and what they're saying that you did?
No,
You don't understand that that's what they're saying happened? Or I'm not saying did that happen, but do you understand that's what they're charging you with?
I comprehend that.
Okay.
I don't understand it.
What do you mean when you say you comprehend but don't understand? What's the difference for you there?
I'm just going off definitions from like Black's Law. I've been doing this for like 6 months, just trying to figure out like how y'all work.
Okay,
Once again, it's my first case.
sure. What does comprehend mean to you?
Do I know what you're saying, what you're talking about, what they're saying?
Uh-huh.
But understand means to like to stand under, to submit to.
Oh, I'm not asking you that. I'm not asking you a trick question. I'm just
Legalese, we're just speaking plainly.
regular, like, do you get it? Do you get that's what they're saying?
Yeah.
Okay. Nothing I'm going to ask you will be a trick question at all. So if it feels like that, just say, this feels like a trick question, or can you re-explain it? Because I just really want to know if you're okay to represent yourself. So I'm not trying to trip you up, or I don't have any dog in the fight in terms of either side here. I just want to make sure that you are capable of representing yourself if that's the decision that you make.
Yes, ma'am.
Okay, so this charge carries with it a possible, and Ms. Velasquez, I'm going to need your help here on the F3 child abuse. What is the possible penalty?
Given that it's SBI and
Uh-huh.
extraordinary risk, we're looking at a mandatory DOC sentence of 10 to 32 years determined by the court.
Okay. Mr. Stickrod, so that is the legal possible penalty under Colorado law. If you were to be convicted of that charge, which is a class 3 felony, it is a mandatory sentence. Mandatory meaning I would have to sentence you to prison, the Department of Corrections, for a term between 10 years and 32 years.
Yes, ma'am. Can I make a counterclaim here?
You can make a counterclaim, yes.
Under, let's say, so when I was arrested without a warrant, and my wife was arrested without a warrant, and they said that we would have a phone call when we got here. They put I have pit bull King Corsos. They put 4 of them in one crate and left them there for 2 days. They've taken my kids without so much as a signature. There was no hearing. They took jurisdiction of my kids without serving me properly, which I have the proof of that too, which they admitted in court. You took my kid from me and you didn't let us talk to her for over 45 days. You understand the psyche that does to a kid?
Sir,
We can't even meet the Fosters. I don't even know who has her.
That's probably for the best. Also, earlier in the video, You stated that the grandparents had them and that you wanted them to change the protection order so that you could have unsupervised visits since they couldn't always get to the location where the supervised visits occurred. Now, maybe that changed between the hearings, or maybe you're just lying to the court.
Okay. So my case is limited to the criminal case. Okay.
It's like connected though.
I know they're all sort of like, they're not actually like connected with each other, but I understand you have a couple cases going on. My question solely for you is, do you understand that if you were to be convicted in this criminal case of this charge, this class 3 felony, that the judge, whether it's me or a different judge sentencing you, but likely me, I would have to sentence you to prison and the term would be 10 to 32 years.
I know what you're saying.
Okay. You get that part. Okay. And you don't have to tell me your defense, but have you decided on a defense to the charge in this case?
I didn't plead not guilty. I pled way of demur and tort claims.
You pled not guilty on.
And talk about it beforehand.
Okay.
That's also another reason. Because I was told I can't talk without my lawyer talking for me. I think you were the one that said that to me one time when I was right here.
Probably.
But that's because I have a tendency, because it involves my family. So
Yeah.
It's kind of emotional for me. So I just kind of.
Sure.
But I don't mean to disrespect you or the court.
I don't feel that way at all. But have you thought about a defense to this criminal case? To the charge that the people have brought against you? Have you thought about what your defense is going to be? Is it like a denial? This didn't happen? Is it?
Did they investigate the person that I kicked out of my house on November 4th for doing drugs? For smoking meth and blues in my basement?
Okay, so
Did they even investigate?
Okay, so is it like an alternate suspect defense or?
He claimed head of household so that he could get more food stamps. And so now my wife doesn't even get her benefits. We get $25 a month of food stamps now and my military disability. And it's at 80%. It's not even 100%. So like we were already struggling.
Yeah.
Because I took a little bit of time off from work when my wife was pregnant for the last couple months. But I was just getting my feet back in the door. Then my sewer main backs up after I kicked this guy out because they wanted cheaper rent, so they screwed with my plumbing. Next thing you know, my son gets sick. Sheriff department leaves my door and my garage door open, my front door and my garage door open. I got raided for what, four nights in a row, something like that, 3 nights in a row. And homeless camp moved in. Cut my plumbing in my basement.
I think we're getting a little off track. I don't want to
I
interrupt
know,
you.
but I mean, it's like they know that somebody else did it, and yet they still just go after me because I brought him to the hospital.
Are you actually saying that someone else didn't feed your kid and it was their fault that he almost died? Yeah, you should have kept your lawyer. At least he wouldn't be saying the stupid underscore you're saying right now.
Okay, so it sounds like you're saying someone else did it and it wasn't you. We can summarize that. And I don't want you to tell me anything more than that, really. I don't need to know anything.
I guess my defense would be,
Again, I don't need to know what it is, but just, have you thought about it? Have you decided on one? It can be, we call it a general denial. This didn't happen. It can be another person did it. It wasn't me. It could be an affirmative defense, like, and this I don't think applies here, but like self-defense, like that kind of thing.
I wanted to, I got problems with the affidavit.
Okay.
And I've also got problems with the police officer that testified here because I told him exactly what I was telling you.
Okay.
And then he said, oh, I don't know why he went to the hospital. I was like, well, because he's been sick the last couple of days.
Okay, let's hold on there, sir. I don't need to know this level of detail, okay?
Well,
And I'm stopping you. I'm not interrupting you to be rude, but you are being recorded and I don't want to know anything about the facts of your case.
I'll,
If you need to better understanding of why I'm saying this, you can ask Mr. Stafford, but I don't want to know about anything that happened with bringing him to the hospital or anything that happened. My only question is just, have you thought about a defense? Yes or no?
yes,
Okay.
I'd say jurisdictional,
Jurisdiction? Okay.
personal subject matter.
Okay.
This is, of course, a criminal hearing.
Okay.
Is it an Article 3 court or is it? I don't.
Um,
And then I just wanted proof that everybody hears the government. Because it's to my understanding that under Section 1, Article 8, DHS isn't included or covered by Congress.
okay.
So when they impersonate an officer by serving a warrant,
Mhm.
I have a little bit of an issue with that.
Okay. Let me ask another question. So, sir, Mr. Stickrod, do you understand I am not allowed to give you legal advice? So if you represent yourself, I cannot comment on the viability of your defense and I express no opinion about it. So do you understand that? I can't say that's a bad defense or,
Now I just finally got what he was saying. Okay, yeah.
okay. Do you understand there may be legal rules that limit the use of your defense? And you would be expected to know those if you represent yourself. So if you proceed with your self-representation, you need to be aware of that there may be legal rules that limit your defense, and you would be expected to know those. I can't tell you those. Do you understand that? I could appoint advisory council and they could give you some pointers and things, but ultimately you would be required to know those.
Do you have a list of rules and procedures?
The rules and procedures that I follow are basically everything in Colorado law. So my question for you is, do you understand that there are legal rules in the statutes, Colorado Rules of Criminal Procedure, case law that might limit the use of any defense you have, and you would be expected to know those if you represent yourself?
So does the Social Security Act, does that matter? Like what I'm saying is, like, if it's repugnant to the Constitution, it's null and void, I think, from Marbury versus Madison, which
So-
Social Security Act, they require my consent, which I revoke all consent and I revoke all contracts.
Okay,
I've never seen
Mr.
contracts.
Stickrod, I don't know if you're understanding my question. I'm not having a conversation about Marbury versus Madison or the Social Security Act. I'm just asking, do you understand that the law might limit the use of your defense, whatever law that might be? Marbury versus Madison, the Constitution, case law in Colorado, statutes, and you are expected to know those if you represent yourself. It's just a yes or no.
No.
You don't understand that. Okay.
I know what you're saying. I don't understand anything. I can comprehend what you're telling me.
What about what I just said? Do
I
you
don't
know?
understand anything.
Can you tell me what you don't understand about what I just said?
I know what you're saying. I can comprehend it. I can identify it. I don't understand anything.
Okay.
Just as a legal term, I know we said that we wouldn't speak legalese or whatever, but this is recorded, and so I'm kind of weary.
If we
I'm
go,
using the term understand.
I'll just tell you that if we go through this advisement and you say that you don't understand what I'm saying, I'm not going to let you represent yourself because you have to understand these things because there's a lot of gravity to them. And representing yourself is a very big responsibility. And if I give you this whole advisement and you say, I don't understand anything you're saying, I'm not going to find that you're capable of representing yourself.
That'd be a violation of due process.
Okay. And you're entitled to think that, but you're telling me that you don't understand that the law might limit the use of a defense, that you don't understand that, you would have to know that.
So is the issue
I'm not,
the fact that I won't use the word understand?
the issue is you are telling me you don't understand what I'm saying. That
know
is
what
the
you're
issue.
saying. I don't understand.
Okay, I'm not playing word games. It's not a word game for me.
Okay, well, I know what you're saying then.
Okay. But you're also saying you don't understand what I'm saying. Like you,
I
what
know
I
what you're
hear
saying.
you saying is you're hearing the words that I'm speaking, but you're not understanding them. And I'm not going to do this with every single question,
But
sir.
I
I'm just not.
comprehend what you're saying, and I
Okay.
just won't use the word understand.
Okay.
That's my only qualm, is I just won't use the word
Can
understand.
you tell me what the difference between understand and comprehend is for you? Because that might help me better advise you.
One of the side definitions for understand besides comprehend would be to stand under, to submit to automatically accept whatever charges.
Your A understand. Nowhere in any dictionary, nor in the etymology of the word understand, does it mean to stand under. What he's citing here is what a lot of softards call quantum grammar. Meaning words have more meaning than they actually have. But this judge finds a way to get around the massive stupidity block.
Do you grasp the meaning of what I am saying?
Correct.
Okay. Do you understand or do you grasp the meaning of the difference between a general denial and an affirmative defense? It's fine if you don't. I'm just asking, do you
I
grasp the meaning of that?
I grasp.
Okay. And do you grasp the meaning that if you do not raise an affirmative defense in a timely manner, you can be precluded from asserting that defense at trial? Do you grasp what that means?
I know what you're saying.
Okay. Do you grasp the meaning that I would be required to apply the same rules to you that I would to any attorney? So I treat you and Ms. Velasquez or Mr. Stafford all the same. I have to apply the same rules to her, to you, to him. Everybody gets treated the same rules apply. Do you grasp that?
Is there a little bit of leeway with the adjectives and verbs? So y'all, you're the way y'all word stuff is pretty skillful. I don't know why y'all took years to become lawyers and stuff, but
It's just in terms of the rules that apply. So the same legal rules. I don't require anybody to speak with a certain vocabulary, but I do apply the same rules to you as I would to any attorney. Do you grasp the meaning of that?
I know what you're saying.
Okay. Do you grasp that criminal law is complicated and an attorney trained in the field could be of great help in preparing and representing your defense?
Very much so.
Okay. Have you had any training in law generally? And it's fine if you haven't, like the rules of criminal procedure, rules of evidence, any training in that?
Not formal training.
Okay, but like informal training or informal exposure?
Correct.
Okay. Do you grasp that you have the right to represent yourself? And I want to emphasize this, that by doing so, Mr. Stickrod, you take a great risk of not properly handling your case. Okay, you know that. Do you know what a motion is? Okay, a motion, as it sounds like you know, is either an oral or written request from a judge to rule on a matter. So that's related to the case. Suppress evidence.
Motion to dismiss.
Motion to dismiss, motion in limine, it sounds like you know what that is. Do you grasp that if you represent yourself, you will be responsible for raising any legal issues you believe are relevant in the case?
Yes, I know what you're saying.
Okay. And I cannot do that for you. Do you know that?
Yeah.
Okay. If I see that there's a great suppression issue here and you don't catch it I cannot bring that up for you. Do you grasp that?
I know what you're saying.
Okay. Do you grasp that that the right to raise a legal issue can be deemed waived if it's not raised in a timely manner?
I know what you're saying.
Okay. And do you know what a contemporaneous objection is?
No, I'd appreciate the definition.
Okay. That means that, let's say a witness is testifying and there's something about their testimony that's objectionable. Let's say it's hearsay. A contemporaneous objection is they're testifying, you get up and you say objection, hearsay. You don't like wait until the end of the day and say, I want to object to that witness's testimony from 4 hours ago. It was hearsay. Contemporaneous means in the moment. Do you grasp that?
Yes, I know what you're saying.
Okay. And if let's say we go to trial and you're convicted, the general rule is you're only allowed to appeal those issues which have been adequately preserved in the trial court, either through a contemporaneous objection or filing a motion or something like that. Do you grasp that?
I know what you're saying.
Okay. Do you know how to do legal research?
Like looking up like Cornell or Wexlaw or
Yeah.
no, I know.
Okay.
Research.
Okay. Do you know that you have the right to confront and cross-examine witnesses who appear against you at a trial or an evidentiary hearing in the case, and that you would be responsible for coming up with the questions to ask those people? Do you know that?
I know what you're saying.
Do you know that you can call witnesses? So you can subpoena witnesses to testify at the trial or an evidentiary hearing. But if they're not willing to come voluntarily, you would have to do a subpoena to compel them to come, and you would be responsible for doing that. Do you grasp that?
I know what you're saying.
Do you grasp that you have the right to either testify or remain silent at the trial? And that would be a decision that you would make.
I know what you're saying.
Okay. Mr. Stickrod, there's a difference between testifying under oath. So like if you testified under oath, and there's that, and then there's like standing at the podium like you are now and just making statements that are not under oath. And there's a difference there. This is admissible testimony. Things that you say at the podium are not evidence in the case. Do you know that?
Is this a court of record?
Yeah.
Then isn't everything I say typed up for the record? Courts or whoever looks at it, after.
Everything's part of the record, but there's a difference between testimony under oath and just statements made at the podium.
Yeah, I know what you're saying.
Okay. We're almost done here. If we were to go to trial, you may only comment in opening statement on evidence that you in good faith anticipate will be admitted during the trial. Do you know that?
Can you repeat that?
So if we go to trial, you are only allowed to comment in an opening statement that you make to the jury on evidence that you believe in good faith will be admitted during the trial. Do you know that or grasp that?
So I only talked the one time? Then
You can only, an opening statement is members of the jury, let me tell you what this case is going to be about. And then you can only talk about evidence that you have a good faith basis to believe is actually going to be admitted during the trial, not stuff that you don't have a good faith basis to believe is going to be admitted.
So that means I talk first and then they present their case?
They go first, actually. It's their burden of proof. We're just talking about opening statements.
So I was reading the code and conduct of prosecution or judgment prosecution, something like that.
Okay.
And it says, like the job of a prosecutor is to state the facts,
Yeah.
not paint a picture. But what I saw the last time I was here was a whole mural being painted. So I don't know, like, what when I'm arguing for the affidavit, like trying to what's it called? Challenge the affidavit and challenge the testimony of the police officer that was here.
Mhm.
Because I'm gonna say allegedly.
Okay, so we're getting off track again.
So
I just want to make sure with this question. When you have a trial and the jury is sitting here and you're making your opening statement. An opening statement is just each side makes one at the beginning of the trial if you want to. They do theirs and they say, you're going to hear from these witnesses and they're going to say A, B, and C. You're going to be able to get up and make an opening statement if you want. You get up and you can only tell them you're going to hear evidence. And you have to have a good faith basis to believe that that evidence is going to be admitted during the trial. You can't talk about something that you know is never going to be admitted. You're going to hear from a witness that says this and like there is no witness that says that. You can't do that, but you can only talk about what you have a good faith basis to believe is going to be admitted in the trial in the opening statement. Do you grasp that?
I know what you're saying.
And likewise with closing argument, so the trial happens, now it's over, they make a closing argument. Everybody, you heard all this evidence, and I'm asking you to do this. You get the same opportunity. You can only talk to them about the evidence that was admitted. You can't be like, oh, and there was also this other lady who was at the hospital and she said A, B, and C, but no, we've never heard from that person during the trial. You can't do that. Do you grasp that?
I understand what you're saying.
Excuse me, did you just say that you understand? I understand what you're saying. Well, there you have it, boys and girls. He understands. So, by his own logic, he stands under the jurisdiction of the courts. Let's go.
Mr. Stickrod, do you still wish to represent yourself?
Correct.
And I'll ask this again. And I just want to emphasize again that the mandatory sentencing, and I'm not saying you will be found guilty, but obviously there's a risk of that, that if you represent yourself, you are taking a very great risk of not properly handling your case, which is a very great risk for many reasons, including the mandatory sentence to the Department of Corrections here. Do you grasp that, know that, comprehend that?
I know what you're saying.
Okay. And you are requesting advisory counsel, what you call the standby counsel?
Correct.
Yeah. Do you grasp that person's only role is to explain legal terminology and procedure to you? Do you understand that or know that or get that?
Only terminology.
Legal terminology and procedure. So they can't, they don't represent you. They're just like you said, standby advisory. You can ask them, is this like, what's this motion called? That kind of thing.
So I can't bounce cases off of them like that.
I mean, I think you can. They can explain legal terminology and procedure. So I don't know all of what they all do, but the essential thing to get is they are not representing you on the case. They're not filing things for you. They're not getting up and questioning witnesses. They're not making your arguments for you because you would be doing that. They are just advising you.
Yes, I know what you're saying.
Okay. And you would be the one to ultimately make the decision about what motions to file, which defenses to endorse, which witnesses to subpoena, and any other decisions that an attorney typically would make. Do you get that?
I know what you're saying.
And if you were to be convicted, you would not be allowed to bring a post-conviction claim of ineffective assistance of counsel against advisory counsel, meaning that if you were convicted in the case, you wouldn't be able to petition the court and say, I want my conviction to be set aside because my advisory council did a very bad job. You would not be able to do that. Do you get that?
I know what you're saying.
Okay. I'm willing to give you an opportunity to think about this if you want to, specifically whether to represent yourself, to get a second opinion. Do you want to do that and talk to another attorney before you make this decision? Or are you prepared to make that decision today?
Can you restate that?
So if you want to get a second opinion about your case, if you want to think about whether you actually want to represent yourself, I'm happy to give you additional time to do that, meaning like a week. Or maybe you're ready today to tell me that you either want to represent yourself or you want to stick with your attorney. I'm just saying if you want an additional week to give it some thought, I'm happy to do that, but also I'm happy to proceed right now.
When is the trial date?
August 18th.
Here's my thing. I'm gonna be homeless by the time we even get to that date.
Okay.
Because of this. Now, I don't know if it was maliciously done or whatever, but when I get hit with 2-3 month continuances and stuff, it's not like it's just going to be another Tuesday or something. So I don't really know how to recover from this.
Okay.
Even if I win, I lose. So I don't really know how to handle this. But yes, I would like to represent myself
Okay.
because I think there's just certain stuff that I can do that he can't do, or, I don't want to put them in a compromising position, whoever represents me, because I know I'm probably going to say some wild crap, but
Okay. Is anyone pressuring you to do this against your will?
y'all, I don't want to be here.
Is anyone pressuring you to represent yourself against your will?
No,
Okay.
I don't want to participate in any of this, but I have to.
Okay. And Mr. Stafford, I for some reason thought this question was at the beginning of my advisement, but it wasn't. In your opinion, is Mr. Stickrod presently competent to stand trial?
Yes, Your Honor. I think he has different legal theories and ideas than I do, but I don't see anything that indicates he is incompetent to proceed.
And has he been able to consult with you with a reasonable degree of rational understanding of these proceedings?
Yes.
Okay, thank you. All right, Mr. Stickrod, thanks for going through all that with me. I have observed your demeanor. I've listened to your answers to my questions. I find you to be appropriately oriented and rational. I have no evidence that you're under the influence of any prescribed or unprescribed medication, alcohol, or drugs. I have not witnessed any behavior which would cause me to feel the need to raise an issue of competency. You have been represented by court-appointed counsel. He confirms that you have been able to consult with a reasonable degree of rational understanding, consult with him about the proceedings. I find that you do have a rational and factual understanding of the proceedings against you, and Mr. Stafford agreed with that. I am persuaded that you have made a knowing and informed decision to represent yourself. I find that you understand the dangers, disadvantages, and responsibilities of self-representation, and you wish to exercise your right to self-representation in spite of those dangers, disadvantages, and responsibilities. I find that you have made a knowing, voluntary, and intelligent waiver of your right to counsel. I will permit you to represent yourself. Mr. Stafford is released from the case. This is not a conflict finding. The court just notes that Mr. Stickrod wishes to represent himself.
All right, so that's almost the end of the video. The court is going to permit him to represent himself, even if it is to his own detriment. But before we shut this show down for the day, There was a brief exchange that resulted in some more dipshittery.
So since this whole thing has started, life's going like a little crazy, you know what I mean? Like, just with all this. I can't work. Is there any way to get any type of compensation to like pay my rent and stuff while I'm doing this?
No.
Okay.
Okay. Ms. Velasquez, anything else?
I have nothing, Your Honor. I guess just hearing this go back and forth and maybe concerned about motions being filed. But obviously that hasn't been done, so I will just wait and see if anything occurs.
All right. We will be in recess. Thank you.
Oh, wait. Are we doing? What do you mean by recess?
Like, we're done.
What did you think she meant by recess? Like, did you think she was saying it's time for you to take your lunch crayons out to the monkey bars and play with your imaginary friends, which may or may not include the druggie that you intend to blame the child neglect on? Alright, guys, that's the end of the video. It was a long one, and he'll be having more court appearances coming up before his jury trial, which takes place in August. So, if you like the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic and I'm out. Here we